But on 11/6/2024, the notice came to be served upon me. I would send a communication to the investigator on 11/6, which has acknowledged it on 12/6. Your Lordship would get your Lordship left-hand side bottom the acknowledgement given for my communication. I am aware that I have been arraigned as an accused in the above crime number. Notice under section 41A of the CRPC dated 28/3/24 has been issued to me on an earlier date. Pursuant thereto, I have taken part in the investigation and extended my full cooperation. Another police notice was issued under section 41 capital A of CRPC to appear on 12/6/2024. The same was received by me by one of my staff on 11/6/24. However, due to prior party engagements at New Delhi, in relation to my political party, I have left Bengaluru, and as such, I am unable to appear before the investigation officer on this occasion. However, kindly underline this. I would personally appear before the investigation officer on Monday, the 17th of June, 2024. On 12th, he receives my communication. I have some exigencies and work in Delhi, party work. I am going there. Kindly condone my absence. I would mark my attendance before you on 17/6. But what is it he does? He doesn't wait for 5 days. But what he does is, he goes before the jurisdictional magistrate and he would make an application. But on 12/6, he would make an application, the day on which I was required to appear. By then he had received my communication also, requiring him to permit me to mark my attendance before him on 17/6. What he does, kindly go to page 127. Andre 41A notice ಕೊಟ್ಟರು ನಾನು ಬಂದಿಲ್ಲ, therefore issue a warrant under section 73. But when can the court issue the warrant under section 73 would be the next question. Kindly have a look at page 127.
When he is evading investigation.
No, my lord, no. Where I am absconding.
Are absconding?
Have a look at section 73, my lord, for a second, just to refresh my lord's memory. Have a look at section 73. Warrant may be directed to any person. The chief judicial magistrate.
Escaped convict, proclaimed offender.
Always proclaimed offender, escaped convict. Avaru kodbeke vina. This magistrate, my lord, at a point of time when he accused himself, would say that I don't need to arrest you.
This may be a different case.
Disastrous consequences.
Every day I am seeing cases of 73 being issued for the asking.
But disastrous consequences would follow.
The asking, and proclamation being issued under 80 to 83 for the asking.
So how can he exercise? Well, there is no question of me challenging the order of issuance of warrant passed under section 73. That is why I am knocking at the doors of your lordship. Grant me the benefit of anticipatory bail, because the Damocles sword of an arrest warrant is hanging on me, on my neck. What is wrong in me asking for the grant of the relief of anticipatory bail? Well, he wanted to overcome section 41A. He could not have arrested. He would issue me a notice. I would mark my attendance before him. I would cooperate with the investigation. The only date on which I would remain absent according to him, with an explanation which I would give as to why I am not in a position to appear before you on 12/6 is, I have got to go to Delhi. I am coming on 17th. I am not entitled for the grant of the benefit of anticipatory bail. In fact, strictly speaking, I don't know how far your lordship would agree with me. It is a case of contempt. Actually, that is how the Supreme Court has said. In Satyendra Kumar Antil case, that is how the Supreme Court has said, following Arnesh Kumar. It is a case of contempt. To overcome a lot, so that he could take a shelter. No. I was not interested. The court, I appealed to the court. Court ought to have rejected it. Court issued a warrant. Therefore, I wanted to lay my hands upon you. Immediately, the very next day, I am before this court. And an interim order came to be granted.
Yes. That is on that.
That is on that.
Merit.
Merits will go on.
Yes.
Notes illa.
ಅದು vacating stay ಅದೊಂದೇ ground ಆ? Vacating stay application
Yes, vacating stay.
and
Sir,
that
notes
and 6 months ಅಲ್ಲಿ conclude ಆಗ್ಬೇಕು proceedings ಅಂತ ಅದೊಂದು.
Proceedings.
Notes is-
ಮತ್ತೆ more importantly, kindly turn to section 30.
ಅದೇ that last time you referred to that.
Yes.
Yes. Evidence should
He
get
should be-
concluded.
Yes, no, he should be present when the statement is recorded. Then the victim statement is recorded and it's mandatory that it should be recorded
Yes,
in his.
Ah,
And
yes.
that has been prevented by this interval.
yes.
Please.
Has frustrated the mandate.
Proceedings. Frustrating the mandate of the statute.
Mandate.
All right, yes.
The date of offense is on 2/2/24,
2 ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಾ?
between 11 and 11:30 AM.
ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀರಾ ಏನಾದ್ರು?
ಹಾಕ್ತೀನಿ,
ಪರವಾಗಿಲ್ಲ, ಎಸ್.
ಹಾಕ್ತೀನಿ. Violation is not synopsis. 2/2/2024, between 11 and 11:30 AM
11
and 11:30 AM at the residence of the petitioner.
at the residence of the petitioner.
Yes, my lord, the offense would take place right under public gaze.
Yes.
My lord, the
Public
complaint is
gaze-
not filed on
No, no.
2/2/24.
Public gaze is discernible by what?
Yes, my lord, from the presence of more than about 20-25 persons. 20-25 persons had assembled.
Let him show one sentence.
ಈಗಲೇ ತೋರ್ಸ್ಬೇಕಾ ಅಥವಾ ಆಮೇಲೆ ತೋರ್ಸ್ಬೇಕಾ?
ನೀವು ಮಾಡಿ.
ಇದೆ, ಈಗಲೇ ತೋರಿಸಿ. Visitors book ಇದೆ. ತೋರಿಸಿ. The manipulated visitors book is there.
Manipulated.
Yes, sir.
Yes.
That is proof.
Yes.
ಅಲ್ಲ ಈಗಲೇ ತೋರಿಸ್ಲಾ ಆಮೇಲೆ ತೋರಿಸ್ಲಾ ಅಂತ ಕೇಳಿದೆ ಅವ್ರಿಗೆ.
ಇಲ್ಲ, ಹೇಳಿದ್ದನ್ನು substantiate
ನಾನು
ಮಾಡಿ.
ನೀವು ಅದನ್ನ ಜ್ಞಾಪಕ ಇಟ್ಕೊಂಡ್ರೆ ನಾನು
Continue,
ತೋರಿಸ್ತೀನಿ.
sir.
ಒಂದೊಂದಾಗಿ ತೋರಿಸ್ತೀನಿ ನಾನು.
Yes,
The fabrication of evidence made by you in this case, I will show you to
Yes.
the court.
yes.
My lord, 2/2/24 is the date of offense, a very serious offense. That is what the law and special public prosecutor has been canvassing. The complaint was not on 2/2/24. The complaint was on 14th of March 2024.
After 35 days.
Yes, my lord. After 1.5 months, nearly. 1.5 months later to the date of offense, the complaint. In the meantime, in between 2/2/24, she would visit me half a dozen times
Why?
to be more, well, for my favor, to put a word to A, B, C, D, warrant in connection with an alleged rape case or an act of rape said to have been committed on the person of her daughter. She would visit me. She would come to me.
Yeah, the
She-
complainant.
Yes, my lord, the complainant, along with her daughter, who is said to be the victim in the case, she would take pictures with me. Between 2/2/24 to 14/3/24. But she is a notorious lady. I shall take your lordship to that. How many cases are registered against her?
Not a derogatory remark against the person who is no more.
Huh.
Let him not.
Oh,
do that.
complainant is no more. Yes.
Complainant is no more. She is dead. Why should such a remark on it?
All right, let the records be taken through.
Better, better,
Yes.
better, sir, better.
Hmm.
The court will certainly formulate the opinion, or you can formulate the opinion when I take how many cases, 56 cases. ತೋರಿಸ್ತೀನಿ,
ಬಿಡಿ.
ನೀವು ಸ್ವಲ್ಪ ತಾಳ್ಮೆಯಿಂದ ಇರೋದಿಲ್ವಲ್ಲ ನೀವು ಯಾಕೆ?
ಅವ್ರು ಹೇಳಿ, ಒಂದ್ ಕೇಸ್ ತೋರಿಸಿ.
All right, sir,
ಕೇಸ್ ತೋರಿಸ್ಬೇಕಾ?
wait.
ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ಅವ್ರೇನೋ ಕೇಳ್ತಾ ಇದಾರೆ, ತೋರ್ಸೋಬೋಣ ಅದಕ್ಕೆ ಏನಂತೆ. Kindly go to Annexure D at page 24 of my writ petition.
20,
24. Annexure D of my writ petition.
next shall D.
I'm sorry, I said 50. It is wrong, my lord. I apologize. It is more than 50.
Page,
Page 24. She would file a complaint not only against her husband, against her son, against the ADG, DG, well, the leader of the opposition here in the Congress political party, police commissioner, against anybody and everybody on this earth. Kindly turn to page 24 of my writ petition. This is the background.
that is this red petition 15522.
Yes, my lord, 15522 at page 24. Which they are not disputing. The state is not disputing this chart which I have furnished.
Chart ilwala.
ಇದರಲ್ಲಿ Annexure D, my lord.
Yes. ಇಲ್ಲ, this is the final report charge sheet, annexure G.
ಅಲ್ಲ ಪೆಟಿಷನ್ ಜೊತೆಗೆ
Petition copy.
Petition.
ಪೆಟಿಷನ್ ಜೊತೆಗೆ
One minute, amended red petition.
ಹೌದು.
ಅದರಲ್ಲಿ 24
Yes.
yes,
Unamended, right?
sorry, yes.
ಇದು ನಾನು ನನ್ನ ಲೈನ್ ಆಫ್ ಥಿಂಕಿಂಗು ಥಾಟ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಹೋಗ್ತಾ ಇದ್ದೆ. ಇವ್ರು ಮಧ್ಯದಲ್ಲಿ ಇದು ಮಾಡಿದ್ರೆ ಇದನ್ನ ತೋರ್ಸೋಕೆ ಪ್ರಮೇಯ ಬಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ಇದ್ರ ಬರ್ತಾನೆ ಇರ್ಲಿಲ್ಲ.
Yes,
Kindly see, my lord, this chart which I have submitted to your lordship along with the writ petition for kind consideration is not in dispute. In fact, they would say, yes, this is correct. First case is, well, in all these cases, she is the complainant.
53 cases.
Yes, my lord. Against whom? Well, I shall take one after the other. Well, our first case is in crime number 790 of 2015.
Again for child sexual abuse.
Yes, my lord. She is in the habit of filing complaints after complaints, petition after petition. Against whom? I shall take your lordship one or two sentences.
Ah,
Well, our first complaint is at Electronic City Police Station for offense under section 376 and 506 and 468 and 12 of the POCSO Act. She is the complainant. Next, second is crime number 264 of 2016 under 328, 381, 506, Red List section 34 against her sister. But
ಗಂಟನ
now kindly go to next case, Electronic City Police Station 269 of 2017, 323, 341 against her son. Fourth complaint at Hudumao Police Station, 186 of 2018 against her husband. Kindly go to next case, item number 5, crime number 188 of 2023 against her son. Well, now kindly go to page 26, item number 7, against the Additional Director General of Police of Karnataka. Item number 7. This, they would say, no, it is only a petition. A petition for action against the Additional Director General of Police in or in relation to a honey trap case. Well, at 8, 9,